Good morning and welcome to the Borderlines podcast. We are here today again with our good friend and colleague, Eoin Logan, who's from KSW Lawyers. Eoin, if you've seen him on a previous episode, Eoin has a very unique practice in the sense that he is focused very much on litigation that is related to immigration, but really is focused on negligent practice related to people who are representing people who are doing immigration applications. So works very closely with the immigration bar and is here to discuss a number of cases that we've pulled out for discussion. Welcome
Eoin,
again.
Thanks for joining.
Thanks for having me.
You've been keeping busy?
I have been very busy, yeah.
Yeah, it's very exciting actually, because Eoin's been working on a whole bunch of cases, has been getting referrals from across, I think, the province for sure. But it's finally nearing this very long wait for some of these cases to actually start appearing before the court. So we're all waiting with kind of bated breath to see how some of these actually turn up. So we'll have them back definitely in January after these hearings start actually coming through. But yeah, it'll be very interesting.
Well, and the other reason that I like having Eoin on is, Deanna and I know quite a bit about Canadian immigration law, but one of the fun things about doing this podcast is to speak with people who do other areas of law, and torts is not an area that I know as much about. We have some cases lined up involving disputes between individuals and I think in these three cases, immigration consultants. Not to say there can't be disputes against lawyers as well before we get possibly told off for that, but these cases just happen to involve consultants. And what I'm hoping is that the audience today will learn a few things about tort law, how lawsuits against consultants work, how contracts work, and so forth.
I think it's also really interesting always talking to Eoin, because I think when people are thinking of creative ways to run their practice, you're like, oh, I've got an interest in immigration, but what can I do with the skills that I have as a civil litigator, and just thinking outside of the box, because you started out in wasn't it personal injury really, or civil litigation? What was it exactly?
It actually, I started off in debt collection. So collections work. So moved on from, we started off doing, we were doing work on behalf of the federal government. That was the firm where I worked as a paralegal, then did my articles. And then part of that contract was doing defense claims for the RCMP when people would sue them in negligence, things like unlawful arrests and things like that. And then that transitioned into personal injury defense. And then from there, I started doing this practice. So it's quite varied, to say the least.
Yeah. But I think it's really cool because he's kind of created his own area of law, and he's now the guy in British Columbia who does this type of work. And I think found just a real niche area, and there's a huge it's you have to be a visionary and see that this is an area and created it and have the patience to see it through, because it will sometimes take 2 years before you start seeing those cases hit the courts. But I think he saw an opportunity there and just went for it, and now starting to see the fruits of all that labor come out. So it's really cool.
Why don't we actually hit with one question right off the bat? Deanna just mentioned, it can take years. Eoin and I were recently discussing how long it takes in the context of where somebody has been, say, ripped off or scammed by their representative. An issue that will obviously arise in a lot of these cases is that they may not be in the country for long. So to what extent is that an obstacle?
Yeah, that's a really good question, and it's one that we get asked all the time, because the people who are the other side of the consultations from me, their status is up in the air. They often don't know where they'll be in 6 months or a year. So commencing a civil litigation claim in BC, you don't need to be a resident. It just has to, the jurisdiction for the claim has to be here. So that's often where the defendant is based or where the contract is. So often in some of the contracts, you'll see in them, it says, we are torn to the jurisdiction of BC. So that means the case has to go ahead there. So the person doesn't have to be in the country. However, you have two dates that are sort of important for being present, and that's your examination for discovery and the trial. So it's possible to do the examination for discovery on Zoom, but the trial you really need to be here in person because judges want people in the courtroom for it. So
if someone's visitor visa is refused for their own trial, what would happen?
Yeah, that isn't something that has come up yet. It's something that I'm worried about because if, for example, someone was found to have misrepresented and they get a 5-year ban from Canada, it's going to be very hard for me to get them in the courtroom here. And I think in a situation like that, we would have to make an application to the judge, probably the trial judge on day one of trial, to say, hey, this person cannot come to the country because of the issues at the center of this case. Are you okay with them appearing by video? And I think given the practical problems, I hope the judge would say yes, but you really never know what they would do. Some judges will need to have the person there in person and some people will not. So it's one of those things that it's like, you would hope it doesn't happen, but there is, the solution always is apply to a judge and try and get some sort of solution to it. You can't always guarantee you'll succeed on those.
Mm-hmm.
Yeah, well, this is kind of part of the reason that we end up working so closely with Eoin is that a lot of the times we're dealing with clients where, because of the negligence of the representative, whether that's a consultant or a lawyer, they are out of status. And so the immigration lawyer will be working to try and get them a temporary residence permit or a humanitarian and compassionate, whatever. We're trying to deal with the immigration issue. He's trying to deal with the negligence claim. And so we end up working arm in arm to try and keep them in the country or get them back into the country while this other thing is going on. That's at least how it's worked on cases that we've collaborated on.
Mm-hmm. Another question before we get to these cases. Again, I always have all these, as soon as you get the opportunity to ask knowledgeable people about these types of questions, you want to take them. I've seen some of your posts on LinkedIn regarding sort of the state of professional regulation for immigration practitioners. What is your general sense? Is the system protecting immigrants?
Yeah, I do post a hell of a lot about predominantly complaining about the college in these things. But I think ultimately the system isn't protecting immigrants in a way that it should be. And I think my issue with it often comes down to not that the rules are bad. I think the rules are pretty good on paper. And I think the college has some good legislation and code of conduct. I think the major issue is actually the enforcement of those rules. So they're good on paper, but they're not being enforced in person, and not being enforced quick enough or strong enough, I think. So, a decision I often point to when it comes to the college is there was a disciplinary decision that came out in April of this year where a lady forged 39 instances pretending to be the federal government issuing letters saying that the person got a work permit. And these letters that they had, I think they all had the same UCI and application number, but different names and addresses and dates on them. And so for me, you've got 39 letters with the same UCI. That's a 2-minute investigation as far as I'm concerned to see that there was fraud. But it took them nearly 2.5 years in that investigation before they temporarily suspended her license pending a final decision. So I think that's a good example for me of how long it takes for the bad actors to be held accountable. And in that 2.5 years, she's practicing without supervision, without audits, and potentially, doing this over and over again. And so I think the challenge when I think people aren't being protected properly, I think, is that the enforcement's too slow and too weak.
Yeah, I mean, the government, we're probably going to have to do an episode dedicated to this at some point, but the government, I think in part because of this frustration, is going to be bringing in a system of directly fining consultants, lawyers, and I think unauthorized representatives as well for misrepresentation. I don't want to get too sidetracked, and we'll probably do an episode, but a couple sentences, thoughts on whether that will bring. What are your just thoughts on the government, stepping in directly to fine?
I think the best solution to all of this is to take it out of the hands of the federal government and to move it to the provinces. Saskatchewan has their own provincial regulation system for consultants and recruiters, and they actually enforce the rules and fine people pretty regularly there. And I think that's the best way to do it, in my view. It's closer to on the ground, and it's taking, the federal government doesn't have a great history in terms of doing the enforcement and these fines. But if you look up the work they're doing in the province of Saskatchewan, they're fining and taking action against people every like 4 or 5 days. It's a very, very effective, and it's only a 4-person department, but they are doing really, really good work and clamping down on the bad actors pretty well there.
Well, it's really interesting because I was just talking yesterday to our friend and colleague Sadaf Kashfi, who we were talking about before we started recording, and she said she started seeing, because she also does criminal work, seeing criminal prosecutions for immigration offenses, and that was something that I didn't realize was happening, and she's seen a huge uptick in that. And so again, like these two different schemes running alongside. I wish we had invited her to this episode as well, because I feel like there's a lot of different things interplaying here.
Yeah, there is. It's fodder for a whole separate episode, I feel like.
CBSA calls them projects. So there's always a project name behind any of their investigations into big immigration fraud, I find. Okay, let's get into the cases before we forget. So the first case, this one was discussed in the National Post, which is how it came to my attention. It's Sibbal v. Nathyal, Alberta decision, 2025, Alberta Court of Justice, 198. And the basic gist of this decision was that an individual who was had a postgraduate work permit that would be expiring. That's an open work permit. Our listeners, a lot of them will likely know that extending postgraduate work permits is impossible. The government, with its stricter requirements now, has made getting a labor market impacts assessment difficult. It can always be a struggle for people to find employers to employ them. And so in this case, Sibbal was told by Nathyal that if he paid $15,000, Nathyal would help him with a letter of endorsement in Alberta. This letter of endorsement was never obtained, and Sibbal wanted to get his money back, right? Like, he basically said, I paid you $15,000 for you to help me with my immigration, not through, it seems, a legitimate means. Nathyal isn't a consultant. It looks like it was going to be, judging from the case, a fake offer of employment or something like that. So he sought his money back, and the case gets into what is called the doctrine of contractual illegality. Maybe, Owen, before we get to the results of this case, do you want to kind of explain what the doctrine of contractual illegality is?
Yeah, you know it's serious law when they start breaking out the Latin for these things.
Ex turpi causa non orter actio.
Oh my God. First of all, is a letter of endorsement a thing, or is this just something that was created?
I think it was a thing, but I'm also not the immigration expert.
Yeah, I know, but it's not a thing at a federal level. It must maybe it's
not. If anything, it's an Alberta thing. It's not a thing in British Columbia.
Okay.
Yeah. So this is, I mean, to put it very simple, the court won't enforce illegal contracts. So if, for example, Steve and Deanna wanted to import cocaine to Canada, and Deanna paid Steve $15 million.
As we're wont to do.
Yeah. I shouldn't be giving away all the stuff we talked about before.
Exactly.
And you paid Steve $15 million, but Steve never showed up with his boat with all the cocaine for you. You can't go to court and enforce that because drug trafficking is against the law and it would be a criminal act.
Right.
So the court will basically say, if you've all entered into an illegal contract, we're not gonna enforce that. Is the very simple way. And so there's a couple of paragraphs in here where they've explained why they consider it illegal. And it's, I think, the final paragraph where they've said it's actually contrary to public policy. So They've said there's laws and rules against all this, but it's contrary to public policy to monetize the immigration system. And that was the reason they kind of wiped their hands from this case and said, this is illegal, contrary to public policy, so we won't enforce it.
Yeah, I can read the last two paragraphs, which is, quote, this court has a responsibility to preserve the integrity of the legal system, and this involves ensuring that claims seeking to enforce illegal contracts or unjust enrichment claims based on illegal contracts do not result in an inconsistency in the law. Submitting fake job offers or employment contracts, providing advice to do so, and charging fees beyond those expressly permitted by the legislation are all illegal under Canada's immigration legislation and undermine the integrity of the immigration system. The monetization of Canada's immigration system is against public policy. Sibbal understood his contract with Nathyal was illegal. Considering the underlying public policy as expressed in the IRPA and the regulation agreements that flow from it, the fact that both Sibbal and Nathyal were equally blameworthy in the transaction and the proportionality of the results, Sibbal does not have any entitlement to have his contract with Nathyal enforced, nor is he entitled to any remedy.
So is the reason that he knew it was illegal because he was not supposed to be paying for the job offer, or because the job offer was not genuine?
I think it was both. So he, in the judgment, he says that they were both aware that this contract was illegal. So that's like when you look through, you see that, I guess you can see right on the screen there, he appeared to represent himself. And so he probably didn't understand making that admission to the court was actually going to be pretty bad for his case. And so it's certainly not something you would try and not say that if you were trying to enforce an illegal contract. You might want to, present it that you were unaware that it was exactly illegal, or you weren't sure if it was against the rules.
There's something about the decision that just sits badly
me
with me, because there's like a bit of a power. I just feel like there's a power imbalance between the person who's desperate to stay in the country and the guy who wants to rip them off.
Was this person an authorized consultant? I didn't really get that.
No, there doesn't seem to be any real, well, whether they were an unauthorized consultant, maybe. They weren't a regulated consultant.
Okay, I got it.
Yeah, he's not registered in the college registry, and there's no indication he was ever like an RCIC that was qualified. And their description of him, involves him having an office with a computer in it. So it's a bit vague exactly who he was or what he was doing. Seemed to be somebody kind of trying to make stuff happen for money through illegal means, I guess.
Now,
this is a buyer beware kind of
individuals paying for jobs is a huge issue in the immigration system. It's regularly reported in the media. Is there a way for people like that to seek compensation or get their money back? Like what would distinguish this case, say, from one where you are able to get someone, at least partially refunded?
Yeah, it's I certainly wouldn't have proceeded with on a case like this in this fashion, because I would never have never put in evidence that everybody knew it was illegal. And he also put in evidence how desperate he was to stay. So one of the things that I suppose that's important in it is that he wasn't a consultant. He was just somebody sort of offering kind of a quick scheme to fix a problem. I think the decision would have been different if this was an immigration lawyer or an immigration consultant offering this, because they would have a different sort of relationship with the person. There'd be a duty of care that applies. But there is
a fiduciary role or something.
Yeah, exactly. Because lawyers, we have to act in the best interest of our clients. The same is said in the consultant's code of conduct, right? And so offering kind of illegal schemes to your clients isn't acting in their best interests. This guy wasn't, he was an unauthorized practitioner, if even that. And he was, his illegal scheme he was offering was just illegal. There wasn't kind of any duty. So.
Whereas an employer would also have Employment Standards Act obligations. Yeah.
Exactly. This is almost like kind of a back, dark back alley sale of something where the court says whatever you two agreed upon, we're not touching because it was all illegal. And I think what I would have done if this was me, I think I would have taken the case on a fraudulent or negligent misrepresentation. So that's where you can rely on the person, on the kind of imbalance. Like, I was desperate to stay and they lied to me about the prospects of this succeeding and not. And that way you can enforce things like that if you're able to prove the other person was either negligent or lying in what they told you. But it's tricky. It is very hard because you also don't know what decision each individual judge will make. So it's possible you could have got a different outcome depending on what judge this was in front of as well.
Interesting.
Mm-hmm.
Next case is Roshy Skincare Clinic and Roshank Kazimanian, probably pronounced that wrong, against a whole host of people, companies. The neutral citation is 2025 BC Supreme Court 1769. It's a very long, it's a
when you have an index at the front of the decision, you just like.
But it's basically the main facts boil down to someone who represented. So again, this isn't an immigration consultant, but someone who, from what I understand from the judgment, pretended to be one. And just skipping ahead, it's quite different because here that person was ordered to pay $40,000 and I guess compensation, punitive damages of $50,000. So the first thing, you kind of hinted at this earlier when you talked about negligent misrepresentation, which was how this proceeded. Do you want to maybe, while I find the relevant paragraphs, kind of summarize what negligent or fraudulent, or the difference between negligent misrepresentation and fraudulent misrepresentation, and why that difference may even matter?
Yeah, this is always a tricky one to prove because the difference. So what you have is a misrepresentation. That's a statement that's incorrect that was made by a person. And the difference between a fraudulent misrepresentation and a negligent misrepresentation kind of comes down to the intent of the person who made the misrepresentation. So did they intentionally lie to you, which would be fraudulent, in order to gain your money? Or did they tell you something that they didn't necessarily know was untrue, but should have known was untrue? So that would be negligent. So, for example, I'm trying to think of an easy example, I guess, but if you were to lie to somebody to say, this car works totally fine, you should buy it, and you relied on that representation and bought the car and it wasn't fine, that would be fraudulent misrepresentation. If somebody had done a quick assessment on the under the bonnet and looked at the car and said, yeah, in like my opinion, this car is totally fine, my opinion as a mechanic, and you found out it wasn't later on, but you were able to prove that they should have seen something when they opened up the hood to see that it was wrong, that would be a negligent misrepresentation. And depending on the power imbalance between the two and the knowledge imbalance between the two is going to depend on where you want to go with those types of cases.
And I assume fraudulent misrepresentation would generally is more serious than negligent misrepresentation.
Yeah, if you can prove the person intentionally lied to get that money from somebody or to get them to do something, the court looks on that much worse. I'm going to guess that's why they got the punitive damages on this file, because if you're lying to a person specifically just to get the money, to get money from them, it's kind of like running a scam on them, and the courts don't really look very kindly on people who run scams to get money from people.
Yeah, so the court found that someone named Mr. Lofty made a fraudulent representation to Ms. Kazemian to induce her to sign the immigration agreement, represented to the person that he had the necessary expertise and qualifications to advise her on immigration matters and secure PR, may not have used the words immigration consultants, but for all intents and purposes, falsely represented that he was a qualified immigration consultant. And then there's, the topic of damages, which is being made whole, essentially. And then there's punitive damages. So maybe do you want to touch on punitive damages and where you see them in your practice as well, like where you argue that there should be punitive?
Yeah, I wish I saw them more is going to be the quick answer to it. So punitive damages is what the court will award when they want to punish somebody for doing something wrong. So it's where they've said, for example, aggravated damages is where the conduct was really bad and it warranted more damages. Punitive damages is where they issue them to kind of say to other people who are from the same profession or same background, don't do this because it will gain you punitive damages. So, one of the famous cases that people always talk about was the McDonald's case in the US where the person burned their lap with coffee, really strong coffee, really hot coffee. And there was I think it was like $18 million was the award, but it was basically almost all a punitive damages award because they wanted to punish McDonald's for doing this thing. And they came up with that figure because that was the amount of money that McDonald's made daily from selling coffee. So they basically fined them one day's worth of sales. And they said they did that so that McDonald's would understand the severity of the situation and stop selling coffee at, I think it was something ridiculous, like 160 degrees was how hot the coffee was.
I listened to a podcast on it. Apparently when it gets that hot, it expands. So you actually like need less coffee. And that's why they were doing it at that temperature.
Oh.
Oh my God. And now we have those helpful warnings. Caution, hot.
Yeah. And a good Seinfeld episode.
Oh,
exactly.
I have missed that.
And so in my practice, like we'll plead punitive damages quite often, because we are often suggesting that in situations where people have lied or misrepresented immigration programs and things like that, this is worthy of punishment and worthy of rebuke by the court, and that should serve as a warning for other people intending to do things like that. How punitive damages play out in practice is you are almost never going to get punitive damages in any kind of settlement. The only real way to get punitive damages is to get in front of a judge and convince them this is really something serious. So in my trial I did last year, in October of last year, where we were suing a realtor for breach of his fiduciary duty, we had made the pitch to the judge that we should get punitive damages because we said realtors, they owe a duty to their clients to be honest and transparent. And the court didn't award punitive damages for us in that case because they felt it wasn't something that rose to the level of worthy of rebuke is their phrase. So
does it turn into a settlement stage? Like if they were like, I don't know, if you said you wanted 5,000 in punitive damages, would they ever respond, well, we don't want it classified as punitive, but just add it to the general damages? Like, is there something taboo, like that people just don't want the word punitive?
Well, if you're dealing with insurance companies, they'll have different buckets of money, and they probably won't put any money towards punitive, and they'll not want to make that admission that they're giving something towards it. But quite often what you have in terms of settlement discussions is you're just going to get figures from the other side that are all in. So it doesn't tell you exactly what they're giving you for each bucket. And you do that so we're not all falling out over how much money is in each bucket and, you're shorting us on this one. And
that can be an insurance thing of what the insurance company will cover.
Yeah, exactly. It can be, yeah. Like they can cover anything in terms of a settlement just to get it resolved.
That's why we have you on. We learn all these interesting things. So in this case, high hand. So yeah, they awarded punitive 50,000, stating that this person knew that Ms. Kazemian desperately wanted to be a resident of Canada, knew that she only spoke Farsi and did not know Canadian immigration laws, and that he preyed on her vulnerability for his own gain, which is worthy of rebuke.
I'm interested in this context whether or not there's an expectation that the claimant has done some kind of due diligence.
I think that's important evidence to put in there because, like, the issue you had in the Alberta case was the guy said to the judge, well, we all knew this thing was illegal as we entered it, but you have to come and enforce it for me. Whereas in this case, the plaintiff was represented by two lawyers here at trial. And so they will have done a better job at pitching this to the judge and painting the picture within the lines of different types of lawsuits and like getting the evidence in that the judge will want to hear to be more sympathetic and things like that. So I'm sure that when they had them on the stand doing their direct evidence, they would have explained, here's the reason I was so desperate to stay. Here's all the things I did to figure out how to stay. Here's the research I did. And then this golden opportunity landed where this person promised these things as the court found them fraudulent. And that's why I jumped at it, because of the situation. And that's a lot more appealing to a judge than, well, we all knew this was illegal. So, but still enforce it for me, please.
But is there like, if somebody was a bit naive or reckless, or they did not go back and do their own research, would that undermine their ability to bring such a claim?
It can do. It can do. Like, it really does depend. A lot does depend on the judge you get, and whether they're sympathetic to those types of arguments or not. And that is something that we have to explain to clients all the time, is that there is risks when you go to court, that the judge you land in front of will just not see things the way you see it, and you can't be convinced that they're going to make the same decisions as you. So one of the things that, like, most mediators have a version of this analogy that they give to people, where they say, if you and the other lawyer were to pick some random person from a cafe and you both get 30 minutes to pitch your side of the story to that person, how much do you want to bet they're going to side with you on it if you have to pick one side and one side only? And most people in that context say, well, I don't think they'll do that because they don't know anything about me. But when they think of a judge doing that, for some reason, everyone thinks, well, the judge is definitely going to find in my case. So you have to.
You were saying before we got on that there was something in Ontario this week where the same matter that proceeded only by writing with no further submissions, I guess, was accidentally assigned to two judges who on the same material before them rendered opposite decisions. And it's now this question of like,
what do you do?
What?
Yeah, that's exactly.
What are they doing?
It's a perfect right now.
They say like, what?
They're
trying to
not
imagine the criminal context. Like,
statements.
a judge being like guilty and another judge going not guilty.
Yeah, no, it's really serious. And I don't know that it's an unprecedented situation in a way, because both of these decisions got published. So, when they went to publish, I think they were one day apart when they got published. So I think maybe one came out on Monday, one came out on Tuesday. And I guess they never checked before they published them whether they had those decisions out or not. And so it's a great example of what two different judges will find based on, this was, not just the same set of facts, but this was the same written submissions, materials, case law. It's literally a perfect kind of social experiment that they didn't intend to run. And they are left with a really challenging situation now in terms of how they're going to resolve it. I haven't seen anything online about how it will get resolved. But it's a great story for clients to explain to them. Anything can happen with different judges.
Yeah, it's also one of those things that kind of makes me but it brings me back in mind of the episode we did with Professor Sean Rehag many years ago about truth is in the eye of the beholder, and there's no one specific outcome that is the clear and obvious and quintessential outcome of any particular hearing, and so it depends a lot on the adjudicator.
I mean, I think we've all read decisions where you think to yourself, I'm surprised this went this way.
Yeah, for sure. For sure.
Yeah.
The
last one before we open it up to both audience as well as Deanna and my questions. This is civil resolution trial, which, as far as I understand, is like a small claims court.
Yeah, it's for claims less than 5,000.
Less than 5,000. So this is an immigration consultant suing a company, and it's actually a pretty interesting set of facts that get into sort of contractual performance, in which case here a consultant was seeking invoices paid or invoices rendered of 4,000. And so basically, I'll just go through the facts quickly. In early 2020, this company hires the immigration consultant to provide services relating to the hiring of 2 foreign nationals. They have 2 retainer agreements, one for each person, which says that they'll provide labor market impact assessments as well as work permit applications for these workers. The company agrees to pay $8,000 payable in installments upon certain milestones. This probably all looks very familiar to individuals who hired immigration lawyers or consultants. The consultant says that the company failed to pay the last installment under each retainer agreement, a $2,000 payment due upon the submission of the work permit applications. Now, kind of the curveball, first it sounds like the consultant tried to also go after the workers, and the court found that they weren't actually a party to the contract. There's also a suit, and maybe you can we'll pause this discussion for later, the effect of a complaint to the college on litigation. But sort of the issue that arises is that so the consultants submit the work permit application and then apparently falsify a rejection letter. So the company says that it refused to pay the invoice because the consultant intentionally falsified official correspondence from the government of Canada, which resulted in the company learning about the rejection of the work permit over 5 months later than it should have, which was then well after the window to appeal the embassy's decision, right? Judicial review would be 60 days. So they forged they got a refusal, and for some reason they waited 5 months to show it. They did this twice. And the company said we got this yesterday, but it was clear that the company or that the consultants were lying. They tried to remedy it a bit. The embassy was saying this isn't our problem. So, we didn't do anything wrong. This is between you and your consultant. And the judge found that the consultants admitted that they altered the date of the rejection letter, but that they still wanted to get paid because they did perform the service of submitting the work permit application.
It's pretty ballsy.
It's bold. It's bold. And so what the but factually, right? Like the retainer agreement says you have to pay for the application being submitted. It was submitted. And then this is where the judgment for me anyways was interesting. It's like what the law is. So it says, I also find that the parties' retainer agreement includes a duty of good faith and honest performance. This means that the consultant had an obligation not to exercise their contractual rights in a way that misled the employer. They found that they intentionally did lie, and so by doing so, breached the duty of honest performance, and that therefore they also, I guess, waited to issue the invoice until after the refusal, which wasn't good for your argument, but that basically because they had lied and hadn't performed their contract honestly,
they had frustrated the contract essentially.
It goes without saying that the company hired the consultant to submit the work permit in hopes that it would succeed, that while they agree with the consultant, that the consultant isn't necessarily responsible for the outcome and even would get payment if it's rejected. The fact that they failed to inform the company about the refusal breached this duty of providing professional services, and therefore they aren't entitled to the services that they performed. So that's quite a lot, but the general gist is that even if the work was done, because the consultant wasn't honest with the company, they didn't have to pay the invoice. What else, Owen, can you tell us about this duty of honesty?
Yeah, so there's, I suppose, in terms of the big picture, there's a lot of implied terms and duties that go with contracts that are not necessarily included in there. And so this is one of these duties of good faith and honesty is sort of implied in all the contracts. And it's I think the words that the court would probably say is a flexible doctrine. In other words, it can be applied liberally or narrowly depending on what's kind of fair in the situation, and that does depend again on what judge you get. So it's when you're hiring a professional, it's implied that they will be doing the job professionally, and that's acting in good faith, and you have to be sort of honest with people about whether things are going wrong or not. If you hired a plumber to fix a pipe in your attic and the water was streaming down from the attic into your house, and the plumber is standing there saying, I did a good job, I don't know what's wrong, it's much easier to understand that way. You can't just expect the plumber to have duct taped the pipe back together and hope that it would all be good. And so the court looks badly on people who are exercising their duties that they have either contractually or through a duty of care on people to either cut corners or lie to them. So that's what kind of is going on there, if that makes sense.
Yeah, I have one where you can be the judge. It remains one of the most wild things that someone brought to me about a dispute with a consultant. So the contract says that the consultant will represent the person, that they'll be, these numbers might be off, but like 5,000 due upon the submission of the work permit, 5,000 due when they apply for permanent residence, and 5,000 due upon the person becoming a permanent resident. The consultant represents them in the work permit application. The person then on their own submits the permanent residence application, which is approved. And the consultant, when they learned that the person had done this and got permanent residence, tried to enforce the contract saying, when you become a permanent resident, you're supposed to pay us $5,000, even though the consultant never actually represented them in the application. Enforceable?
I don't think so, because
I would hope not.
Your contract is for the provision of services, so either giving advice or filling out paperwork. And if you didn't give advice or fill out paperwork for them, what do you deserve the money for? Yeah,
that's where I would have come down.
Bang the gavel. Agreed.
Yeah.
Yeah.
I do want to touch, the question that we have is not so much related specifically to, we got a few. So this is more a mandamus-y question, but I want to spin it a little bit in terms of, have you had cases or come across cases? I would imagine the bulk of what you're involved in are people who are failing to get permanent residence or face deportation. Do you see cases involving delayed or refused citizenship applications, like as far as damages go and things like that?
No, I don't think I've ever actually had anybody come to us for a delay or an issue with a citizenship application.
What about delay for PR?
We have those, yeah. So the majority of our cases are people for extending work permits or getting work permits or getting PR, and we get some part of those delay issues. Like we had somebody refer a case to us recently where had the person put in the correct information, their CSR score would have gone to, I can't remember what it was, but it would have got them a invite at the next draw, and in the 6 months following that, the score never dropped to that low again. It never would have got them an invite. So if the person had done the job correctly, they would have got that specific invite, and later it went higher. So that's an example of like the kind of cases we get where there's a delay in kind of you're getting your invite for a PR. It doesn't guarantee you PR, but it takes that step towards it.
And then we have this good one on Instagram. I've quickly summarized it. We've had episodes on this where there's an argument in federal court that can be made to get a decision set aside where the federal court finds that counsel was incompetent. If the federal court makes that type of finding, is that a slam dunk for a negligence claim?
I feel like I should be asking you this question back, Steve, from the conference we did in June when we answered this one. But the answer is that it would be very persuasive evidence. A decision from a different tribunal doesn't bind the court, but it certainly makes very persuasive evidence towards them that if this other tribunal found this was incompetent or wasn't done in the correct way, that will be very persuasive, especially in a context where the federal court, for example, is kind of specialist in terms of immigration applications and these judicial reviews, whereas the civil court very rarely deals with immigration issues. So they'll probably give a lot of deference to a tribunal that's more specialized in hearing these cases that made that finding.
Interesting.
Mm-hmm.
Actually, Drewski's not gonna like what I'm about to do, but I'm gonna turn a very detailed question that's very specific and probably requires, an email to actually review it. But it's a question that, as I was reading it, made me think. When you encounter a decision that you're like, okay, someone was negligent, to what extent would the individual, would the other side argue, well, they could have sought judicial review and they didn't? Does that come up? Yeah, maybe the person was incompetent, but they could have pled incompetence of counsel to get it set aside, which would have mitigated their damages. Is that a thing?
Yeah, you've pretty much nailed it there. It's the mitigation argument. So anybody taking a civil case, you're under a duty to mitigate your damages. So that means you can't, you have to do your best to make them better. You can't make them worse. And I think it's open to argument and definitely open for them to make submissions that there was alternative routes a person could have done for any immigration program that would have mitigated their damages and got to that level. In a situation like that, I think the argument I would have in response is that the person didn't have the funds available to take that course of action, and you can't ask a person to kind of, bankrupt themselves in order to do everything to mitigate their damages. So, I mean, and one of the other challenges they'd have with that mitigation argument, they say their argument is you should have JR'd this decision to have it set aside. You would have to, in terms of making that argument, prove that they would have succeeded in that JR as well, which is also really hard for proving that decision maker will make that decision, which I feel like is the theme of everything I'm saying today, is that you don't know what decision makers will make.
Yeah, I have to, I think we all have stuff coming up. We'll have to wrap it. I do want to say, for those who are not watching on YouTube, you should check it out, because there's a ghost behind Eoin. And at the Canadian Bar Association conference, Eoin was handing out little ghosts.
Oh, right.
Right?
Yeah.
As this hilarious swag that I just noticed towards the end, that there are ghost consultants in his office.
It says on it, ghosted by your consultant, ?
Amazing.
Yeah.
As Deanna said at the start, he's built a niche.
Built a niche, definitely.
Thanks for coming on, Eoin. We will, we'll see you soon.
Yeah, my pleasure as always to see the two of you.
Yeah. January.